Loma doesn't need an introduction. She's been here several times over the years. But Loma Wharton is our guest speaker. She is with Liberators 11 down in Roseburg. And they have a jurisdiction committee, which is, their task is to educate county commissioners in how to get our public lands back. And we all know we desperately need to get them back. So without further ado, I'd like to welcome Loma Wharton.
Thank you, everyone. I am Loma Wharton. This is my brother Dennis and his girlfriend Debbie. In 2012, we changed our name. We're now Liberators 2004.
Oh,
because that's the year that we started holding our government accountable. It's an honor to be here tonight. I've come several times and talked in front of this group before, but teaching Agenda 21. However, what I'm going to show to you tonight where do I start? Anyway, I'll go ahead with introductions. The goal of Liberators2004.org is our website. We have cards up here. If you'd like to take one, we hold our meetings every third Monday at Elmer's in Roseburg. Liberators is also a member of Oregon Liberty Coalition. There's 35 members. Retired legislator Jeff Krupp is kind of like our spearhead of the class. Last year, Rally Around the Flag. Well, no, let me start over. November of 2015, Jeff Krupp came to our class, and we had a young man there named Lance who took this book right here. This is the Eisenhower Report. This report is the inventory of all the lands within the state's control, not owned, but controlled by the federal government or Congress. This is what he synopsized it down to, was a 16-page report. Jeff happened to be there at that class that Lance spoke about that night, and Jeff realized that jurisdiction is the solution to taking back our counties. And so, how many of you are aware of Natural Resources Director for Apache County, Doyle Shamley? How many of you have heard of him? Okay, Jeff brought Doyle up here because of their county's work to take back their lands. He now is their new county commissioner. And I first met Doyle in 2012 when Liberators tried to form National Constitutional Sheriffs Association. Our first seminar was in Reno. We had Ken Ivory from Utah was there. Doyle Shamley was there, and his two researchers, and it is their books right here. RS-2477, Roads are Road Out of Territorial Bondage. This one is Statehood, and this one is the Property Clause of the United States. This is what we're focusing on tonight, but it's these books. Ken Ivory was also there. It's these books that Utah is using to take their lands back, and they have sued to do it. Doyle's organization is called Veritas Research Consultants. Jeff brought him to Oregon. They met with 4 counties, and out of the 4 counties, Douglas County, the county that I'm from, was the one that appeared to be doing everything correct. But on the offshoot of bringing Doyle here, we had Rally Around the Flag, and Doyle did his presentation, and I had the privilege of sitting on the Lands Committee. And you had Lane County Commissioner there, and Herman Bircheiger, and don't remember where he was from. But the entire time that Doyle gave his presentation and asked questions, the 2 representatives, all they could say is, we can't because of the Fed. So what Apache County, Arizona did, after Doyle presented all of his evidence, all of the law, the Constitution, everything, to back up what he was saying to their 5 county supervisors who were all attorneys. They hired Doyle as their natural resources director. They wrote a resolution and an ordinance under health, safety, and welfare to take back control of their fire burns and their roads. Now, imagine this. How many roads are in Douglas County? Your county commissioners under health, safety, and welfare have the authority to clean and log 300 feet back to 3.5 miles in the wildlife-urban interface. How much logging would that be for how many years just to clean and log? That's the authority that they have to do. Why aren't they doing it? By writing their ordinance, Apache County became the lead agency, and that is the stickler. When the county becomes the lead agency, they determine the agenda, they ensure cohesion among agencies responsible for implementing their decisions. What it also does is when the county takes lead agency, it eliminates the Equal Access to Justice Act. How many of you know what that act is? Only one. Okay, what it is, it's the act that allows an environmentalist to sue a federal agency. When the county takes lead agency, there ain't no money down here. And you're looking at up to $750 an hour. Hang on a second. Just for every attorney on that case when they win. So if they're going to come down to county or state court, what do they have to do? They have to spend their own money. You had a question?
Win, lose, or draw, the government pays attorney fees.
Well, you're right. You're
Win, lose,
right.
or draw, that's why the environmentalists have so much money.
That you're absolutely right. And what are those environmentalists doing when they lobby your legislators? Aren't they causing you and I harassment? Doesn't that damage us in some way or another? Aren't those board members of those environmental groups responsible for those damages that they cause you and I? Apache County called the meeting. None of the so-called stakeholders that didn't show had no standing. And Apache County is in Arizona, and they have some of the most egregious environmental groups in Phoenix, but they got on board. Why? Anybody in here tell me why? Once Apache County started cleaning and logging, can you tell me why the environmentalists got on board? Well, guess what? The wildlife came back. The fauna came back. The Mexican spotted owl came back to life. Why? Because it would finally see its food to hunt. At this time, Apache County, that they started this, they had one sawmill, one shift. They had a sawmill without electricity. In 45 days, they had both of those sawmills up and running. And at the end of the first year, they had 4 sawmills. One of them was a state-of-the-art portable sawmill by Logan Brothers out of Washington. And as of today, they now have a pellet mill, and a biomass mill. This has been since 2012. 5 counties around Apache County are doing the same thing. They have taken back control of their lands, their wildfires, and their roads. Doyle testified before Congress, and I handed out to you a Cronkite News. He testified before Congress's Natural Resource Committee. This is their recommendation for every county in the western states to take back controls of their fire burns and their roads. They recommended it. So when Jeff brought Doyle to Oregon, like I said, he brought him to four counties. In our county, he met with Commissioner Boyce, State Representative Dallas Hurd, County Council Paul Meyer. And Doyle told me this himself. He had to tell Paul Meyer, County Council, to shut up 3 times. He didn't know what he was talking about. At the end, Doyle's comment was, by golly, this might actually work. So we brought him up here, And as a result, we have formed a jurisdiction committee from that event to educate commissioners and other public officials. And you'll see that tonight. So in the meantime, I need 3 volunteers. Who would like to volunteer to be a public official? Joe, would you like to? I need these back. So I have one more. Nobody else? Did you want it?
No, we can't see.
Okay.
He was just stretching.
So we can have it work, it might work, but literally not.
The book is for public officials, like I said. So I'm going to run this as if this was a meeting for public officials. They paid to come to this class. So there's 3 things that I want you that you're going to learn tonight. Number 1, you're going to learn the constitutional mandate that Congress has been violating for many, many years. Number 2, you're going to learn where Congress's or federal jurisdiction really is. And number 3, you're going to learn about Congress's Natural Resources Committee's recommendation as a solution for Western states to take back control of their forests and their roads. So at the beginning of this question, at the beginning of my PowerPoint, you're going to see numbers up here. These are 3 questions that I'm going to ask you tonight as a representative. But I'd like to have you hold all questions so that we can get through this. We've got 45 slides to go through. So number 1, why are you here tonight? Of the 3 that I gave the books to. Number 2, what do you expect to get out of this class? And number 3, how do you plan to apply what you learned here? So I'd ask Jo Ray, but she hasn't had a chance to look at the book yet. So, can the federal government lawfully hold territory and land within your county?
Yes.
Slide number 3, the supreme law of the land is at Article 1, Section 8, which says that Congress shall have the power to lay and collect taxes, duties, imposts, excises, pay the debts, provide for common defense, general welfare, on and on and on throughout the United States. At Clause 17, it says that they can exercise executive legislation in all cases whatsoever over where? District of Columbia, which is what? 10 miles square. By what? By cession of a particular state. In other words, the state of Oregon's got to cede them the land for them to have jurisdiction over it. And Congress has to accept it, so they have to purchase it. So when money exchanges hand, what exchanges hand after that? Title. You're absolutely right. For what? And you can see what it says right here. Erection of forts, magazines, arsenals, dockyards, and other needful buildings. It doesn't say anything about forests, does it? No. So what is territory? Territory is a tract of land belonging to under the dominion of a prince of a state, such as the territories of the United States, Michigan, or the Northwest Territories. These territories lost that appellation of a territory once they became a state. So what is residual territory? It's land remaining under federal title. National parks, recreation areas, forests, wilderness areas, conservation areas, wildlife sanctuaries, and so on. Really? The question of territories was dismissed by a single clause applicable to territory then existing, giving Congress power to govern. And what? This is the key word right here. What does that say? Dispose of them. What does that mean? It means to sell. That's Downs versus Bidwell. So federal zones are where? They're Alaska. They're all the western states. And not any of them, under the property clause, have the designation by Congress or its agencies as a federal zone. They're recognized under the collective term as a federal zone, but it's what the property clause says that you're going to read tonight. Regardless of their designation, for whatever purpose Congress or any executive action, such as the Antiquities Act or an executive action of Obama designating a monument, these lands originated as federal territorial lands and they remain subject to the dictate of the supreme law of the land, the Constitutional Property Clause. So, if Congress has the power to dispose of and make all needful rules and regulations of the territory or other property belonging to the United States, why are they holding our forests? So as the property clause gives Congress the authority to adopt any type of legislation for federal lands, codes of criminal law, taxation, and so on, but it's only on their federal lands. In Kleppe versus New Mexico, the court outlined what it believes to be the parameters of the federal property clause power over a federal zone. It also states that this power of indefinite scope is exercised under the authority of the Constitutional Supremacy Clause. Under the express term of the property clause, Congress is arguably constitutionally relegated to the stature of a common proprietor. And remember this word, proprietor, because you're going to see it in the documents that you have tonight. As a proprietor, they can make all proprietary rules and regulations by which titles and territorial lands are to what? Again, we have right here, to be disposed of. So if the Fed must dispose of the land within the boundaries of each state, then as long as the land remains in territorial or pre-statehood condition, Congress can govern the land. When it becomes a state, the land comes under what? It comes under constitutional protection, and the only power that Congress has is that which is delegated under the property clause. Under this clause, Congress, all they can do is dispose of it. They can write all the needful rules they want to dispose of it. So it's not a legislature, Congress is a common proprietor. So why the feds must dispose of the land within the boundaries of each state? Disposal of title in the land is not a sovereign act, but it's a common proprietary act. Congress, again, needs no sovereign legislative power, supreme or otherwise, to meet the requirements under the property clause. It is their constitutional duty to dispose of. That means it's a mandate. So what do federal zones betray? Can anybody tell me? The Enabling Act. So what is the Enabling Act? It's a piece of legislation by which a legislative body grants an entity for its authorization or legitimacy of the power to take certain actions, such as establishing government agencies to carry out those actions. But it also infringes on state sovereignty. So what are the three types of lands that our framers intended Congress to have? Well, pre-statehood territory for creating states, post-statehood public lands, no authority must dispose of the land, no one objects to them holding the land. So if we've got to have post-statehood public lands, why aren't we objecting? And who is it that should be objecting? Is it not our legislatures and our county commissioners? So lands within a state acquired by state legislative consent for specific uses, which means the land must be ceded, Congress must accept it, pay for it, and then title is issued. So now we have some judicial interpretation of the property clause. So how about the present interpretation that we have from the courts on the environmental issues? This judicial interpretation is a destructive aberration of the constitutional equation akin to a speeding train off of its tracks, coming off of its tracks. And we don't know the consequences to this flawed interpretation. It's yet to be known. But it will not be conducive to our freedom as originally won at a great price and sacrifice of our forefathers. So these are books that Doyle Shamley's organization has written. These will be handed out to the public officials when they come to these classes. This is called the Factor Book. And Butte City Water says, these are all the quotes, the quotations from the courts that are in with this too. Federal land laws under the property clause are not of a legislative character in the highest sense of the term, but savor somewhat of mere rules prescribed by an owner of property for its disposal. There's that word again, disposal. The courts even recognize it. In Coyle versus Smith, the court said so far as it relates to the public lands within a new state, federal power amounts to nothing more or less than rules and regulations respecting what? The sale and the disposition of public lands. Abraham Lincoln said that nothing should ever be implied as law which leads to absurd or unjust consequences. And we're seeing those unjust consequences with our land today, are we not? So what is the Supremacy Clause? And where does it apply? It only applies under the authority granted to the government under the Constitution of the United States, the powers outlined in the actual text of the Constitution. I'm going so fast I even forgot my notes. I think I'm doing pretty good. I must remember it. So all other powers delegated to the state are delegated to the states or the people. That's the 10th Amendment. So what does disposed of mean? It's to part with. The man has disposed of his house. He's been removed. Put into another's hand or power. To give away or transfer by authority. Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Now remember what Article 1, Section 8, Clause 17 said. Docks, arsenals, forts, magazines. Nothing in the Constitution shall be so construed as to prejudice any claim of the United States or of any particular state. So what does ceded mean? Surrender it, give it up. October of 1780, Congress adopted a resolution expressly affirming its intent that all lands ceded to it, now that's ceded to Congress, all lands ceded to it, to Congress, shall be formed into distinct republican states, which shall have the same right of sovereignty, freedom, independence as other states. That the ceded lands will be granted and disposed of for the common benefit of the United States. That's the western states. That disposal of the land would occur. The United States shall guarantee the remaining territory of the said states respectively. Are they doing it? No. So what does superseded mean? That means to set above, to make void, ineffectuous, by coming in the place thereof, to set aside, to render unnecessary, or to suspend. Can a law supersede the Constitution or any of its amendments? What has to happen in order to change those amendments? Has to be, Congress has to rewrite the laws. The effect of passion is to supersede the workings of reason. Nothing is supposed that can be superseded, that can supersede the known laws of natural motion. If you jump off the roof, you're going to get hurt. To come or be in place in the room of, hence to displace or render unnecessary, as an officer is suspended by the appointment of another officer. So can anybody tell me where the guarantee clause is? It's at Article 4, Section 4. And what does it read? It reads, the United States shall guarantee to every state in this union a republican form of government. The guarantee of a form necessarily implies a substance, correct? The guarantee of a form of government under the guarantee clause would be hollow without meaning if there was not also a concomitant right of state republican self-governance. In other words, our state must govern itself, must set itself above the federal government. It is supreme sovereign. The guarantee clause guarantees the right of the state republican self-governance. It's entirely consistent with the original object of the claims clause, and the claims clause presumes to secure a right to sovereign state self-governance throughout the state's territory. It guarantees that form of government while at the same time confirming it. New states can be admitted by Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures as well as Congress. So is the state of Jefferson going to succeed? Not without Congress and state legislators letting go of that property. So under the claims clause, it reads that nothing in the Constitution can be so construed as to prejudice any claim of the United States or any of the particular states. On October 10th of 1780, Congress adopted a resolution affirming its intent that all lands ceded to it shall be to form republican states. How do you take a national forest and form it into a republican state? Which shall have the same rights of sovereignty, freedom, and independence as the first 13 states. The ceded lands shall be granted and disposed of for the common benefit of the United States. That's all the states. And any regulation hereafter will be agreed upon by the United States and Congress that the disposal of this land will occur.
Excuse me, as a point of information, when you're using the word ceded, who or whom is the land being ceded by
The
to the
state,
United States?
the Oregon legislature. As in the case of the only land that has, according to my research and our research, the only piece of land in the state of Oregon that has been ceded to the United States was Crater Lake, and that's because it was donated. So the Oregon legislature had to cede the land. First, they didn't qualify it, nor or it has when you cede the land, the governor of Oregon would have to make the recommendation for the parcel of land to be ceded. It goes to the legislature sends that document to the United States Attorney. For what? For qualification under Article 1, Section 8, Clause 17, whether it's a fort, arsenal, dockyard, or other needful buildings. That's its qualification, its constitutional qualification. He then sends it to Congress. Congress accepts it. Money is paid to the state of Oregon. They're issued title. So when they say they own it, ask them for the title.
There's one thing I'd like to throw in here. That land first has to become state property. Right now they're holding how many acres of federal land in here in which they do not own. Right? Title's not transferred in any way, shape, or form until the state transfers the title back to the federal government. The title is created once the state takes possession of it. There's no title before that. That's where there's a real gray area in how this law is handled.
He asked you to explain it again.
Yeah, explain that again, I didn't quite get
Okay,
it. Like the
when-
territory of Oregon
right,
acquired, did the territory, when Oregon was still a territory, did it own property?
No, is, the federal government, when territorial land is federal government land.
Okay,
Okay.
that's in territory.
Then once they become a state, all the land inside the external borders of the state are to become either state land or private, mostly private. Right? So when the federal government wants to purchase a tract of land, wants a tract of land for some reason, for a port, dockyard, or other needful buildings, then they have to go through the process, all right? They apply for the land, the legislature agrees, it goes to the governor, it goes to be qualified, so on and so forth. Then once they do that, then they pay for the land, and title is transferred from the state to the federal government. That
Okay.
becomes ceded land.
No, I can follow that part. Then the question that I have is, how did the federal government come to acquire Oregon back when it was? Who were the proprietors?
That was, what was that, the Northwest Ordinance?
Northwest Territory.
Or that's how they got it, I remember who they got it from.
Yeah, but I mean, what is really going on there? Did the Indians?
It's through treaty, it was through
land?
treaty.
Did they own land or sought, I mean, in the Constitution?
The Indians never owned land.
Okay, because they were not recognized as sovereign?
No, because they didn't recognize ownership.
They didn't recognize what?
No, they didn't have laws of ownership.
Yeah, so somebody, you know, looking at it from the Indians' point of view, somebody comes in and says, I now own your land.
They were conquered.
Well,
Okay, so
Okay,
you're
but-
maintaining by right of conquest, the United States of America
Right.
acquired the land territory of Oregon by right of conquest.
Yes.
well, by conquest, whether it's a right or not, I don't know.
Well, there's no other conquest in by right of conquest.
Just like the Indians
Wrong of conquest.
Indians conquested land all the time. I mean, it went on, if you look at the history of Europe. So the point I'm trying to get to is, once the United States acquired, whether it's through treaty, through conquest, or whatever the case may be, once they created a state, all that land within the state is supposed to become either private or state.
Yeah, no, I have no intention with that, it's just the initial condition of law and justice, whose law and what kind of justice applies.
Well, it's a little late to be dealing with
Yeah,
that.
it is. So, and we'll get into something else too, so. What does the claims clause provide to the states? It provides a protective wall for state territorial sovereignty and jurisdiction. So now we're going to talk about the Admissions Act, or the Admissions Clause. Can anybody tell me where that is in the Constitution? It's at Article 4, Section 3, Clause 1. And it says, new states may be admitted by Congress into the Union. No new states, we've already gone over this, shall be formed or erected within the jurisdiction of any other state by the junction of two or more states without the consent of the state legislature and Congress. So what is this power to admit a new state? Coyle versus Smith says it's not to admit political organizations which are less or greater or different in dignity or power from those political entities which constitute the Union? It is as strongly put by the Council, it's a power to admit states only. So what is the Admissions Act? And why was it written? And what is the federal government required to do under the Admissions Act? Dennis, do you have anything you'd like to add as far as Article 4, Section 3, Clause 1 reads? Okay. Let me go back to 25. So we've asked the questions, and out of all of these questions, it is an agreement with no conditions or burdens on the state. So what does the equal footing doctrine provide for the states? They're entitled to the same respect of the land within their borders including the unappropriated federal zone, which is counterpart to the former British Crown lands in the original states. That's the first 13 colonies. Can judicial interpretation change this doctrine? It's mandated by the Constitution. The judiciary cannot change it. They are legislating from the bench. They have to apply it. So we'll see what Harcourt versus Gilliard said. The soil and sovereignty within their acknowledged limits were as much theirs as the Declaration of Independence is at this hour.
Can you read that again? Soil and sovereignty, did I hear you say?
Soil and sovereignty.
And that term refers to what again? Say the sentence.
Sovereignty,
No, just read the sentence that has soil and sovereignty in it.
the soil and their sovereignty, the state is sovereign above the federal government.
And that initial assertion of sovereignty came about when the United States Congress recognized Oregon as a state.
When the state became, when the state became a member of the Union, they're above Congress. Dennis, can you explain it? You can probably
Well,
explain it a little better.
they are within their jurisdiction. See, each state is an independent nation of its own right. And when they came into the Union, they gave up certain sovereign authority to the federal government. So the federal government could exercise its authority of which the states gave it.
And that's in Article 4 of the U.S. Constitution.
Well, that's part of what is the political standing of a state. They had to give up certain powers, otherwise they'd just be an independent country without any ties to the United States. They gave up these certain powers so they wouldn't infringe on the federal government's authority, because they have certain authorities to deal with foreign affairs and interstate commerce and so on and so on. Right? Other than that, they retained all sovereignty of a nation, state, just like France or England or any other country. So that's what that's speaking of, is they are sovereign over their territory, inside their external borders, over the people and property and things.
Do you own a house or land?
Oh, you were asking me?
Yes.
Yes, I mean, in the
Okay.
conventional sense.
Are you not sovereign over that land? Can I come on your property and tell you what to do with it?
You asked me, are we sovereign?
Are you the head of that? Are you king over your land?
Well, no, I mean,
Well, that's government rent. That's another issue.
It's okay, let's go ahead. Hold your questions if you could until we got a lot to get through. So write them down if you wouldn't mind. We'll cover all of this. So the Equal Footing Clause has long been held to refer to political rights and sovereignty. That's what the United States versus Texas said. So what does the Equal Footing Doctrine promise? If we're equal, we have control over all the land within our external borders in our states and in our counties.
Let me read a court case that might shine a little light on this. Okay, this court case is United States versus Bevins, and it says the exclusive jurisdiction which and let me give you some context about this case. So I was reading the case and not knowing the context. Involved a federal prosecution of a murder committed aboard a warship when it was Independence anchored in the harbor of Boston, Massachusetts. Right? And the defense said that only the state had jurisdiction over this crime, supposedly committed within federal government admiralty jurisdiction. In the argument before the Supreme Court, the state said this: the exclusive jurisdiction which the United States have in forts and dockyards ceded to them is derived from the expressed assent of the states by whom the cessions are made. In other words, they sold the property to the federal government. It could be derived in no other manner, because without it, the authority of the state would be supreme and exclusive therein. So in other words, the federal government would have no right to act whatsoever. It'd be totally the states if they hadn't ceded that land.
Okay, and then to answer your question again, Wikipedia, sovereignty is understood in jurisprudence as the full right and power of a governing body to govern itself without any interference from outside sources or bodies.
Okay, here's another one that'll fit right into that. The states between each other are sovereign and independent. They are distinct and separate sovereignties except as far as they have parted with some of the attributes of sovereignty by the Constitution. In other words, they gave those things to the federal government so the federal government could do the things of which we gave them to do. They continue to be nations with all their rights and under all their national obligations and with all the rights of nations in every particular, except in the surrender by each to the common purposes and objectives of the Union. Under the Constitution, the rights of each state, when not so yielded up, remain absolute. That's Bank of Augusta versus Earl.
Okay. American jurisprudence also says that a sovereign state is a people exercising through the medium of an organized government independent sovereignty and control over all persons and things within its boundaries. The Constitution protects state sovereignty for the benefit of individuals, not the states or their governments. New York versus United States. Again, the Constitution protects state sovereignty for the benefit of who? What are we? We're individuals, correct? Not the state or the government. American Jurisprudence 16, second, on the sovereignty of the states. All these attributes, except those surrendered by the formation of the Constitution and the amendments, there have been retained. In other words, 13 states existed prior to the adoption of the federal Constitution, and before that time they possessed all the attributes of sovereignty. Sovereign powers of the states is necessarily diminished to the extent of the grant of powers to the federal government. Restraints and limitations remain. Now this is another American Jurisprudence, second edition, Sovereignty of States, section 281, and it's in their own words. This is a book that I have that's like the, actually it's thicker than the Eisenhower report. It's about this thick, I haven't read all of it. And pay attention to what American jurisprudence says. New states, upon their admission into the Union, become invested with equal rights, subject to only such restrictions that are imposed upon the states already admitted. So we lost nothing compared to the 13 states. We're supposed to enter equally, right? There can be no state of the Union whose sovereignty or freedom of action is in any respect different from any other state. No restrictions upon any other state other than prescribed upon all the states by the federal Constitution. Congress cannot restrict such a state by bargaining. By the state contracting with Congress, we are in no way bound to such a contract, however irrevocable it is, stated to be, subject to the restraint and limitations of the federal constitutions. The state shall have all the sovereign powers of independent nations over all persons and things within their respective territorial limits. Okay, we have, at this point, we would hand out the Citizens Rule Book, which is the Constitution book. And then one of the books that they would also get is Resolving Contrariety. It's a judicial interpretation of the property clause. That's this one here. We went through that. Under the Northwest Ordinance, the federal territorial governance ceased upon statehood. It left Congress as a common proprietor over residual territory remaining in new states. And that's what this book is all about. As a proprietor over public lands, Congress is burdened under the property clause with a specific and affirmative constitutional duty to what? here's that word again, to dispose of the land. And this is what Pollard versus Hagan says. Under proprietary rule and regulation, they have to dispose of the lands. So, you people that have the books, if you'll turn to page 3 in the book. And the pages are numbered in the top right-hand corner. What we have here is the Weeks Act. The Weeks Act was written March 1st, 1911. And it's an act to enable any state to cooperate with any other state or with the United States for the protection of watersheds of navigable streams, and to appoint a commission for the acquisition of lands for the purpose of conserving the navigability of rivers. But on page 3, I want you to notice the underlining that I have there. Thought I had that turned off. Push the button on the side, not completely, sorry. What it says is that be enacted by the Senate and the House of Representatives of the United States of America and Congress assembled, that the consent of Congress of the United States is hereby given to each of the several states of the Union to enter into any agreement or compact not in conflict with any laws of the United States. Now,
Is that a contradiction in law?
that's a contradiction because you have to stop right there. The Weeks Act is in violation of the Admissions Act. And during the Malheur incident, I was given a Forest Service handbook on capital investments, appropriations, and the maintenance of lands. And the very first, for capital improvements and maintenance, they used the Act of March 13th, which is the Weeks Act. And you can't do this. They can't tell us what our navigable waters and streams are, correct me if I'm wrong, with an act. Can the Weeks Act supersede the Constitution? Can it supersede the Admissions Act?
The Congress can define what those things are. They were defined the way that went.
True.
And they were defined, and navigable waters were defined for commerce.
Okay, go to page 4 in your book. And what's on page 4 is Oregon Revised Statute 272-025, or 050. This is that, and this is interesting too, because at this section of the Oregon Revised Statute, a Board of Forest Conservation is authorized with 2 county court, which are your commissioners, a supervisor, and supervisors appointed by the governor to approve acquisition of national forests. Before approval, by such board of the acquisition of any tract, the consent of the county court of the county wherein such tract or any portion thereof is situated must be given by an order duly made and entered to the record of such court and certified, a copy thereof transmitted to the board. So my question is, has that happened in your county? But if you look at it, if you look at this on your page in here, you'll see that it says what the feds can't own in Oregon. 0.30. Now see, this is where everybody would be looking at the book, and you're not going to see it up here, but 030 is for the acquisition of federal buildings. 050 is county court to approval of any acquisition of forest land. What did I say? With within any Oregon county. 060, why the Migratory Bird Conservation Act violates the admissions clause. And 070, 080, 090, it's for exclusive jurisdiction pieces. So what really concerns me is whether or not any of the county courts approved any acquisitions. I don't know if Douglas County approved the Umpqua National Forest, but I still want to see title issued. So let's move on to the legislative jurisdiction over federal areas.
Loma?
Yes.
If I could just interject for a moment, because we had agreed to an hour, you got about 15 minutes left.
Okay, all right. Okay, let me move on a little bit more. So where is federal jurisdiction? It's at Article 1, Section 8, Clause 17. Didn't we already read that? 10 miles square. The synopsis, and you can go to our website on our downloads page and download a copy of the synopsis if you'd like to go through it. What I want to get to here is an inventory of real property owned by the United States government, state by state, by its agencies or its contractors or its corporations. Legislative jurisdiction over federal areas of real property reported from each county in Oregon and their general accounting services. The types of jurisdiction and codes description in each county in Oregon and its state statute, that's what's all that's in this book. There's several footnotes in the Eisenhower synopsis. I'm not going to go through them tonight. If you want to read them, you can go to the website. I'm just going to scroll through these because I want to get to the, right here. Now, those of you who've got the handouts with you, now mind you, the Eisenhower report is an inventory of all the lands they control within each state. And what it is a deception. Because they want you to believe they have these jurisdictions when what they're really supposed to do is cede the land. But what I want to show you here is on your next page, and this is Lane County. You're going to want to pay attention to the codes right here, legislative jurisdiction, concurrent, partial, proprietarial, number 4. And number 4 is the big gun for the Fed. But if you look at your Lane County, which is right here in the middle of the page, this little tiny section right here where it says jurisdictional code right under the word jurisdictional. If you will go down through all of these, this first paper is the Multi-County Agricultural Forest Service. They have number 4, which is proprietarial interests only. They don't own it. They're a proprietor. What is a proprietor? They're holding it in trust for the state. There has to be a citation to legislative authority. If you turn back to the original page over here on the right, there has to be a state statute to give them legislative authority. There has to be a federal statute. There has to be an acceptance and recordation date. If you look back under the forests, where do you see the last column? Oops, sorry. The last column right here is acceptance and recordation date. If the land was ceded, they've accepted it, they've recorded it. You see anything over here in the 13 forests in the state of Oregon where there's any record of acceptance? The only one you're going to see is Crater Lake, and I've highlighted it for you in your document. I also gave you Douglas County. The back side of the page also shows Camp Adair, Umatilla, Willamette National Cemetery, and John Day Lock. Those are recorded and accepted. The last page is Lane County. I don't have it up there, but if you look on your pages in the jurisdictional section, this little section right there, all those numbers are 4s. The first one, where they have legislative jurisdiction, is what? It's a post office on Willamette Street. The next one is Hasita Head, light station. Siuslaw River. That's it, folks.
Siuslaw River. is
Siuslaw River.
waterway.
So they only control 30,000 acres.
But Norma, where still is that within Article 1, Section 8, Clause 17? Isn't that still a violation?
Yes. What do they have to
The
do?
post office, you can understand.
Yeah, the post office, it's been seeded, but what I'm trying to tell you here is that Eisenhower report is false. It gives you a false reality. It says that this is what the Fed controls. You're absolutely right, it's what they're controlling, but they don't own it. So if they don't own it, what do they got to do with it? What does the Admissions Act say? They got to dispose of it. Now this comes out of the U.S. Attorney's Manual, where Congress reserves such jurisdiction upon the entry of the state into the Union for the purpose enumerated in the Constitution with the consent of the state. Congress acquires property by purchase or eminent domain. I don't agree with eminent domain, but that's another subject for another time. Prior to February 40, cessions of jurisdiction from the state. If they ceded it, it has to be recorded, title has to be issued. So where Congress acquired the property and or received the state's consent or cessions of jurisdiction and after 1940 and has filed the requisite acceptance. So what all of this is going to lead up to for our public officials, and this is the last frame, so I think we're going to make it. The workshop with Doyle entails multiple days. It's going to be 2 days, 8 hours each day total. It's going to be a detailed analysis of the predominant agency and their acts, which are the enabling acts, the rules, the CEQs of Council on Environmental Quality, congressional acts, PEOs, presidential executive orders, court rulings along with substantive comment, and the necessity of disposal and technical land terms. So I'm hoping that through our jurisdiction committee we can get your water and soil conservation people and lands committees and so on and so forth to come to the class so that they can learn, because it's going to take one county, that's all it's going to take. Apache County started it, 5 counties have gone and are doing the same thing. So, questions, answers? What have you learned tonight? Yes, Pam?
I'm wondering what kind of challenges Apache County has faced since they did this? Lawsuits, anything like that?
No,
Wow.
nothing.
Not even from the
Like I said,
environmentalists?
no, because they got on board, they had to get on board. The fauna came back, the wildlife came back, the Mexican spotted owl came back to life.
I agree.
You know, and you're hearing a little bit of rumblings now from the environmentalists that, oh gosh, all these years of not taking care of our land. Oh, what's happened? Maybe we aren't right. But it's courage. Do you have courageous county commissioners? And I'll tell you, the biggest thing you are fighting is when a county commissioner that wants to follow the Constitution is elected, if he doesn't give the people what they want, they unelect him. And we're experiencing that in Douglas County right now. Is our one incumbent and Chris Boyce and Gary Leaf, as was a candidate at that time, went to Apache County in November. They loved what they saw. They said they're going to hire Doyle. I haven't seen it yet. There's other issues that they've been dealing with. But the issue here is to get your representatives to listen to this, shut up long enough to listen to it, as Paul Meyer saw, because it will work. It is working. So, how'd I do? Anybody want to critique me?
I'll do that later.
I knew you would.
Well, my question is
May I ask-
this workshop scheduled already?
No,
Okay.
no, the jurisdiction committee has got to move forward with Jeff to, I mean, if I don't deal with this every day, I showed this two Liberators classes ago. It's something that you have got to stay up with. And I know I probably didn't do as good a job tonight as I did 2 events ago, because going through it and remembering it and everything is necessary at my age, you know. So that's what we've got to do now is, with Jeff's clout, we can send out the invitations to hold this class. Like I said, these books are going to be issued. We did show this to Oath Keepers in Roseburg, and when they saw the 13 forests that have been tied up by the federal government and what lands they actually control, even though the book is deceptive because it appears as though the federal government's doing what they're supposed to do when they need to dispose of the lands, Doyle can show you how to do it. And we've proven it. He's proven it. And he's got all the law and facts to back it up, and that's what these books will be. Yes, sir.
The Bundy standoff over in Harney County, how has that affected this or were?
Well, number one, I thought I had it marked in here. Harney County. Hood River. Agriculture. Harney County, Sequam Loop Station, number 4, proprietor. Bonneville, this is substation, number 4, proprietor. Bureau of Land Management, Burns Admission Site, Fillmore Street, proprietor, number 4. Wild Horse, Rim, Rad, Shell, whatever that is the number 4 proprietor. Lily Lake, number 4 proprietor. Mattis Building, number 4 proprietor. Wilson Springs Engineering Shelter, number 4 proprietor. Fish and Wildlife, Malheur National Refuge, number 4 proprietor.
You know, the thing about- the thing
Post
about
Office, number 1.
the thing about it is, there's no authority for them to have any of that stuff. There's just no authority.
No.
They either abide by the law of the land, which is their law. It's not our law, it's their law. We wrote it for them. They either abide by it or they don't. And it's up to us to see to it that we enforce it.
So then underneath the FLIPMA Act of 1976, then that also is an illegal act, the Federal
Yes.
Land Policy and Management Act.
Yes. Travel management plans, unconstitutional. You cannot supersede the Admissions Act with another act, the
You can't-
Weeks Act.
First
You
thing
can't
is,
do
you
it.
can't take an act and rewrite the Constitution.
Congress
There's
has
one way
to
to do
rewrite
that.
it.
And we know what
Right,
that
and we
is.
have to
right?
approve it
Yeah.
in order for them to.
We have to
do
amend
that.
the Constitution in order to change it.
But what's happened is they've been bribing us. Title II and III funds, and the reason those Title II and III funds are going away is because the counties are misappropriating them. How many of you here own land in the county? Way out in the county. Do you know that you can apply for those Title II and III funds to clean up to 150 feet around your structures? Why don't you know that? What's your county doing with your Title II and III funds? Yes, sir.
What are you on Tommy?
Who?
The blind guy.
Oh, okay.
My wife's worried that I'm being sure somebody.
No, no, no,
Yeah, the question that I wanted to ask, and I think it's the final question that I will ask. If you could advocate for a conclusion or a solution. Now, if I understand you right, it would be that these so-called federal lands under federal, ownership, or lands under state ownership are transferred, deed, title, whatever claim of ownership there is, transferred to the county government. Is that right? Is that the final? Final solution?
See,
No.
the original intent of this country was for property rights of the individual. Because how else do you gain wealth? How else do you prosper if you don't own property? The first thing you own is your body when you're born. Everything after that you acquire, right? Hopefully through lawful means. Right? So the point is, when you acquire land, you use that land to do what? Grow food, to mine, to build a home, on and on and on. The land was supposed to be sold into private hands so that each individual had the ability to prosper.
It's called the Homestead Acts, which
Well,
stopped.
that's just one of them.
That's one of them.
But the
yes.
point being is, any lands of which they are unable to sell or homestead out
Goes
to an
back to the
individual
state.
goes to the state or the county of which it lies. And it would be under state control. It's not supposed to be under federal control. And the primary purpose of that was so the federal government couldn't reach into the middle of the state and control that. We're a sovereign nation state. And the federal government is not to be reaching into the state and controlling the people or the land within it.
How many of you are aware that in order for Oregon to become a state, it was given 6 propositions?
It was given what?
Six
propositions.
What are the propositions?
We'll have to wind this up pretty soon.
Yeah.
I'm sorry, Laura,
That's
because I
okay.
know you had
That's
so
okay.
much more. but-
That's okay. There again, on our downloads page, you can go and read about it. This book is the 3 of us did the research at the archives. Number 1, when those propositions were written, they were to be given to every man and woman of legal voting age to decide yes or no. Instead, the legislature accepted it. So we entered into this union on an unequal footing.
Yeah, what they did is they disenfranchised the voter.
Yeah.
Did what they wanted. And I don't have any proof of this, but my inkling is that the federal government used the lands and so on and so forth to bribe the state. Fundamentally. There's no proof to that.
Could you say, under that condition, technically we are not a state?
No, we're a state because they accepted us, but we did not accept it on an equal footing, and it's up to the state to fight for that footing, to become equal, and be sovereign over all the land within its borders, and get the federal government out of here. They don't belong here. They got their 10 square miles, go live there.
Okay, any other questions or comments? I see you have one, Leila.
I apologize. So what you're saying is that short of being able to purchase the book and studying it, there are some things that we can establish from what you have listed online? Because what you just
Yes.
said, what you really just said was, we gave up. See, I thought Oregon was a unique state in the fact that we were home ruled, and that was a good thing. That's a bad thing?
When you have home rule, what do you have? You have a manager. You have no direct ties to the elected official.
But I thought the
Well,
counties...
within the county. The state government is like all state governments. We have a
Well-
legislature, we have a judicial, we have a government.
Okay, but I'll have to talk to you later, because I don't know of any states, now I understand if you say we've had unequal footing, but I don't know of any states that have greater,
Oh, yeah,
Go east.
east of the Mississippi, virtually no federal land.
well, no, I understand that, but they got a lot of it back initially after for the.
Well, Virginia gave a whole bunch of it to the federal government to make new states, because they had a fast track when we first became a country.
And I just wanted, I apologize, I was actually sitting outside for half an hour talking to a guy who's a manager at a lumber company, Lumber Timber, because I wanted to hear what he had to say, because he's the only person I can go to who's my higher up anonymous.
I'd like to thank all of you for listening to me. Thank you.